Hey everybody. Just wanted to talk to you tonight about the judicial branch of government. So our essential question here is, why is the Supreme Court an important part of our democratic system of government? Which may have, when you hear this question, you think of a very simple answer to that, or think to yourself, it wouldn't be a democratic system of government if we didn't have the Supreme Court. But do you really know the details that make the Supreme Court such an important part of our democratic society? That's kind of what I want you to keep in mind as you listen to this lecture. So tonight, I hope that I'm able to explain the jurisdiction of the different courts, and there are more than one court, analyze the Supreme Court, look at the differences between a district court and an appellate court, evaluate the different ways someone is chosen as a federal judge. We're going to look at the 9 Supreme Court justices and be able to describe the characteristics of a Supreme Court justice. So let's get started. We're going to first talk about the powers of the federal courts. Well, it started off when our country was formed with Alexander Hamilton and his writings of the Federalist Papers, number 22. He says, laws are a dead letter without courts to expound and define their true meaning and operation. In other words, laws are useless unless we have courts to debate and enforce laws. So the judicial system of the U.S. is an adversarial system. It is this way because the courts provide an arena for two parties to bring their conflict before an impartial arbiter, which is usually a judge. Every case is a dispute between a plaintiff, the person who is pressing the charges, and a defendant, the person with whom the charges are being brought against. These defendants are known as litigants, the people who are engaged in the lawsuit. Both the plaintiffs and the defendants are known as litigants. So there are 2 basic types of cases. We have criminal law, where an individual is charged with violating a specific law, and the laws provide punishment for that law. These specific types of laws can be felonies. These are penalties over a year's jail time, and misdemeanors, usually less than a year's jail time. And these types of cases account for 98% of the cases that are heard at state and local level courts. Then you have civil law. This does not involve any kind of charge of criminality. Instead, this is disputes between 2 parties. This is what you see on the People's Court, on Judge Judy. You see disputes between 2 parties. And some examples would be divorce, custody, property, contracts. Court cases like Judge Judy often is just disputes between 2 people, whether it's I loaned my car to somebody and they wrecked it, or somebody cut down a tree that was really on my property, that kind of thing. That is civil law. So let's start at the beginning. John Marshall was the one who really made the judicial branch a powerful branch. Actually, prior to John Marshall's tenure as Chief Justice, the judicial branch played a very minor role in the 3 branches of the government. And so between 1801 and 1835, he helped to increase the power of the court. And what I'm going to do right now is show you a video. It's about 8 minutes long. And it explains the idea of judicial review and how Chief Justice John Marshall helped increase the power of the courts, the judicial courts. So I'm going to pull this up real quick. and show you this video.
It goes back to the election of 1800 when Thomas Jefferson, the Democrat-Republicans, beat the Federalists of John Adams. And it's full of politics because Adams, on the last time he was in office, appointed these judges. And when Jefferson came in, he decided he didn't want those judges.
Back then, the inauguration, the change of administration, it didn't really happen until March. So you had this period where Congress was in session, but the president really hadn't changed.
In that 2 or 3 months, the Federalists and President Adams, who had just lost, they realized they're about to become the minority party for the first time ever. And both the executive and the legislative branches are going to be dominated by their opponents.
So John Adams and his Federalist colleagues are trying to do whatever they can to stay in power. So one of the plans that they devise is to expand the number of judgeships in the federal judiciary.
Adams's thought in all this was, on the way out, I'm going to appoint a whole bunch of judges and they're going to carry on my legacy.
They passed a law that is nicknamed the Midnight Judges Act.
John Adams is literally signing judicial commissions,
nominating people, getting them confirmed by the Senate
into the waning hours of his presidency before Jefferson takes office.
And what's interesting about this is that John Marshall, who ultimately becomes Chief Justice of the Supreme Court as a part of this whole process, previously he is Secretary of State, and he's the one that physically has to deliver the commission to all of these new judges. But they ran out of time.
Whenever Thomas Jefferson comes into office, he realizes that there's all these undelivered judicial commissions for Federalist judges.
There's a stack of commissions on the desk. And Jefferson says, we don't want Federalists as judges.
And he orders his Secretary of State, James Madison, to not deliver them.
It's really a political decision that Jefferson resented the Federalists. He thought there were too many Federalists in the judiciary, and so he wouldn't deliver these appointments.
Well, one of these judges was Marbury.
It just so happened that Marbury had a friend who was the former Attorney General for the United States. And his friend said, well, there was a statute passed several years prior that allowed the Supreme Court the authority to issue something called a writ of mandamus.
A writ of mandamus. It's basically a mandate. So Congress said, if need be, Supreme Court, you can mandate that something happen. So Marbury says, I know. I'll ask the Supreme Court for a writ of mandamus to give me the commission as a federal judge.
Now, there's a lot of irony in this because John Marshall, who was the Supreme Court Chief Justice, was also in charge of delivering the appointments.
John Marshall, who had wanted to deliver the commission to Marbury in the first place and just ran out of time.
So John Marshall gets this request. He's like, ooh, I really want Marbury to get this commission. He's a Federalist. On the other hand, I have this new administration full of anti-Federalists, and I don't want to piss them off.
And as evidence for that belief, the Congress of the United States actually suspends the Supreme Court for a full year.
This was a signal to John Marshall and the other justices on the bench that if you decide this case in the wrong way against the Democratic Republicans, against the Jefferson administration, there are going to be dire consequences.
So John Marshall is faced with a dilemma.
If Marshall rules that Jefferson has to turn over the commissions, he's going to ignore the court order. Imagine that for a second. A president of the United States, Secretary of State, ignoring an order from the United States Supreme Court. What precedent would that set? It would make the Supreme Court an inferior branch of the federal government.
And what's remarkable about this case is the way John Marshall sort of navigates this decision.
In Chief Justice John Marshall's opinion, he essentially poses three different questions. First, he wants to know whether or not there's some sort of legal harm suffered by William Marbury.
He says fundamentally that what the president did was illegal. By refusing to deliver the commission, President Jefferson did not faithfully execute the law.
Next, he wants to know whether there's a remedy at law for those legal injuries.
And Marshall says because Marbury didn't receive that commission, he has a right to sue. And so here we are now 2/3 of the way through the opinion, and it looks like Marbury's about to win.
Then we get to that third question. Can the Supreme Court do anything about it?
And Marshall turns around and basically does a 180-degree turn and says, but we have a problem.
He decides to go back to the Judiciary Act of 1789. And he finds that this writ of mandamus was an expansion of original jurisdiction. It expanded the power that the court has under the Constitution.
What would happen if we could add to the court's original jurisdiction outlined in the Constitution just by passing legislation? Well, that means that you could amend the Constitution with any old act of legislation. Why not amend Article 1, the powers of Congress? Why not amend Article 2, powers of the presidency?
So what does Marshall do? He says, you know what? I don't think that that part of the Judiciary Act of 1789 is constitutional.
Chief Justice John Marshall reasons that the Judiciary Act of 1789 essentially amends the Constitution.
The Supreme Court doesn't have the power to issue a mandate that something happen.
Therefore, the part of the Judiciary Act of 1789, that's Section 13, that adds to the Supreme Court's original jurisdiction, must be null and void. It cannot stand because it directly conflicts with Article 3, Section 2 of the United States Constitution.
And as a result, he declared a law of Congress unconstitutional.
And from then on, established the precedent for judicial review.
Judicial review.
Judicial review.
Which is the court's greatest power. That only the Supreme Court can say what the Constitution is.
This ability to examine laws, compare them to the Constitution, and when there's a discrepancy, to actually declare that law or part of that law null and void.
It is a seminal case that defines the power of the United States Supreme Court. The Supreme Court today has the power to interpret the Constitution and say what the law is solely because of Marbury versus Madison.
Okay. Yes. So what was once an inferior role in the federal government, John Marshall helped to make or increase the power of the Supreme Court. So the Supreme Court is the only the Supreme Court can say what is law in the Constitution. So how is our federal court system set up? Well, at the very top is the United States Supreme Court, followed by the appellate courts, which are 12 U.S. courts of appeals, 12 regional circuit courts of appeals, one U.S. Court of Appeals for the federal circuit. You have trial courts, which are U.S. district courts, 94 judicial districts, the U.S. bankruptcy courts, the U.S. Court of International Trade, the U.S. Court of Federal Claims. Then you have federal courts and other entities that are outside the judicial branch. You have military courts, which are trial and appellate courts, the Court of Veteran Appeals, U.S. tax courts, the federal administrative agencies and boards. So Article 3, Section 1 of the Constitution says that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may form from time to time, ordain, and establish. So these are these additional courts. So let's talk about the jurisdiction of the courts. Now, the federal court system consists of the Supreme Court and then the lower courts established by Congress. Each court has what's known as jurisdiction, or the authority to hear certain cases. So jurisdiction defined means the authority or subject area that a court can hear a case about. For example, break a federal law, go to a federal court, such as robbing a bank. Another example is break a state law, go to a state court, such as speeding. So here are the powers of the federal court systems. You have your federal court cases. I won't read them all, but they hear cases such that deal with federal law, treaties of foreign nation, bankruptcy, cases between two or more state governments, cases that involve the United States government, a state and a citizen of a different state. Federal court will hear that. The Supreme Court, what they do is, first of all, interpret the Constitution. That's that judicial review we just heard about. They determine the constitutionality of state laws. They uphold regulatory laws. They protect civil liberties. And they influence public policy. So there are different types of jurisdiction. You have exclusive. These are cases that can only be heard in federal courts, such as federal crimes. For example, cases involving ambassadors, bank robbery, kidnapping, presidential assassination. Also, things such as violations of patents, copyrights. Those are the types of exclusive cases for federal court. The types of jurisdiction also include concurrent cases that can be tried either in federal or state court. A common concurrent jurisdiction is known as diverse citizenship. It's disputes involving citizens of different states. Federal district courts may hear these if it's over $75,000. The defendant in such states can have a trial moved from the plaintiff's state into a federal district court. Land disputes between people from different states, for example, may be heard in federal district court. You also have original types of cases, courts with the authority to be the first to hear the case, usually within district courts and our trial courts, where original jurisdiction takes place and trials, not trails, are held and juries are also paneled. And then you have appellate. This is the review of final decisions of district courts, Court of Appeals for a lower court case that have been lost. You can also, an appellate court may hear a court where a case is heard for the second, third, or fourth time on appeal from lower courts. It just goes right up the chain. It could go all the way up. It can start off at a lower court and go all the way up to the Supreme Court. So of the federal courts, the U.S. Supreme Court has both original and appellate jurisdiction. U.S. appeals courts only have appellate jurisdiction, and U.S. district courts have only original jurisdiction. So here's a graphic showing the U.S. district courts down there at the very bottom, and the number of courts and judges. The U.S. district courts usually have two types of juries. They usually have a grand jury which indicts. An indictment is only a formal charge brought against someone. So you may just have a jury that's put together simply to listen to evidence and arguments to decide whether somebody needs to be tried for something, or charges dropped. And then you also have petite juries, which determines guilt or innocence. You have U.S. Court of Appeals. There are 12 of those courts, usually on a 3-judge panel. And these appeals are heard to review from lower courts. And then at the top you have your U.S. Supreme Court, your 9 justices. It's in Washington, D.C. It has both original and appellate. It doesn't hear very many cases in the year, usually anywhere from 80 to 150 cases per year. But a case can originate in Supreme Court. It doesn't have to always come from a lower court. So here are some important Supreme Court cases. We heard about Marbury versus Madison, 1803. This created the concept of judicial review. I apologize, you hear my dog barking. So I'm not going to go into a lot of this, but this is the case that gave the Supreme Court its greatest power and gave the Judicial Branch the ability to participate in the checks and balances of our 3 branches. Then you have Fletcher versus Peck in 1810. This was continued to extend the power to review state laws. There was a law passed in the Georgia legislature that was a violation of the Constitution's protection of contracts. Chief John Marshall reviewed this case. McCulloch versus Maryland. This was a historic case where the head of a Baltimore branch of the Second Bank of the United States had refused to pay taxes. The state of Maryland argued that the Constitution is silent on the subject of banks, and so it went to court and went all the way to the Supreme Court, where the Supreme Court found that the necessary and proper clause of the Constitution allows the federal government to pass laws not expressly provided for the Constitution's list of express powers, and this led to the expansion of the federal government and the federal government versus states' rights. Also, so Chief John Marshall also looked at this one and favored in favor of the federal government, where the state was forced to pay taxes, federal taxes. A real blow there for states' rights. Then you have Gibbons versus Ogden, 1824. This broadened the meaning of interstate commerce, further extending the federal authority at the expense of the states. That was Chief Justice John Marshall as well. 1857, Dred Scott versus Sanford. So this is where Congress, this ruled that Congress could not prohibit slavery in the United States territories moving out west, and that enslaved African Americans and their descendants were not U.S. citizens. In this case, Dred Scott had traveled to a free soil state with his master, who died, and so Dred Scott said that he was free, but the issue was taken to the Supreme Court, and it looked at not only citizenship but also property rights, because Dred Scott, being a slave, was considered property. This was Chief Justice Roger Taney that ruled against Dred Scott in a decision 7-2. This was one of the causes of the Civil War that also led to the Emancipation Proclamation, also led to the 13th Amendment outlawing slavery, 1865, and the 14th Amendment that guarantees the rights of citizen and equal protection, which is in 1868. There's a due process clause that says that no state may deprive a person of life, liberty, or due process or proper constitutional proceedings during a lawsuit or a trial. Plessy versus Ferguson, another popular and impactful Supreme Court case, 1896. So this Plessy versus Ferguson establishes the separate but equal doctrine, which made public segregation of blacks and whites legal. This was an 8-1 ruling in the Supreme Court, which essentially said that facilities for both races, if they were equal, then they could be separate. So this is where you saw the separate water fountains, where you saw separate entryways into public establishments like restaurants and movie theaters, for one entryway into the building for white people, another entryway into the building for black people. It legalized the separation of everything from schools, public buildings, hotels, and it wasn't until another court case, and by the way, Plessy versus Ferguson was 1896. It's important that you know the year, 1896. Fast forward to 1954 with Brown versus Board of Education, who, with this case, challenged the separate but equal law or doctrine of Plessy versus Ferguson, and said that it's not equal. It's not equal and fair to make have a law that says black children have to go into a different school than white children. So the NAACP took on the case in Topeka, Kansas. Chief Justice Earl Warren was the Chief Justice ruling in this case, who ruled in favor of Brown versus Board of Education. Thurgood Marshall was the lawyer that argued the case in front of the Supreme Court. Thurgood Marshall would go on to be the first African American Supreme Court justice after this. So the impact of this case was that the desegregation of public schools and later public spaces. Also, the modern civil rights movement in the 1960s stemmed from this court case. And different movements such as busing and affirmative action also came from Brown versus Board of Education. Another impactful Supreme Court case was Miranda versus Arizona. That's 1966. This rule that police must inform you of your constitutional rights at the time of arrest. This was presided over by Chief Justice Earl Warren in a 5-4. So the impact of this is you get Mirandized. Okay, that's where that word comes from. If you get arrested, you have to be Mirandized. The police officer who arrests you has to make you aware of your rights as a citizen. And there they are, right there. You have the right to remain silent. Anything you can say will be used against you, so on and so forth. Hopefully you never have to hear these. But if you do, make sure you pay attention to what your rights are. Don't say anything until you talk to your lawyer. Another very popular and impactful Supreme Court case was Roe versus Wade, 1972. This legalized the right of women to an abortion under certain circumstances. States are allowed to regulate in later trimesters. Viability is the determining factor there. This was Chief Justice Warren Burger in a 5-4 ruling. So what was the impact of this? Well, the continuing debate of pro-life versus pro-choice, mother's rights versus the rights of a child or a fetus. So is still a very hotly debated issue. A lot of people have very strong opinions on both sides. Anytime a presidential election comes, you hear this debate. So the lower federal courts, let's talk about those for a minute. Okay, so your lower federal courts are constitutional courts. These are courts that are established by Congress under Article 3 of the Constitution. Your federal district courts are created by Congress 1789. They're courts. There are 94 district courts, 646 judges, 2 judges per district. Usually they preside alone, meaning there's only one judge there. There's not a panel of judges. They handle over 300,000 cases, and these are some of the types of cases that your federal district courts will handle: bank robbery, mail fraud, counterfeiting, and so forth. The Federal Court of Appeals, which was created by Congress in 1891, this has a 3-judge panel. It relieves the Supreme Court of hearing all of the appeals of the United States, which would take a very long time. There are currently 13 courts of appeals, 12 judicial circuits or regions, and 1 for national jurisdiction. 179 circuit judges. They hear 55,000 cases in a year. Georgia is in the 11th circuit. Our district includes Alabama and Florida. These appellate courts can uphold or overrule, modify the decisions that are being made. There is no trial. There's no testimony of witnesses. It's just the panel of judges looking for errors in procedure of the law. And here's a map, a United States map of the 11 district courses and courts, and Washington, D.C. You have your legislative courts and your special courts. These include things like Court of Federal Claims. If you're going to sue the federal government, that's where you're going to go. It's the U.S. Court of Federal Claims. You have your territorial courts, tax court, veterans claims, international trade. So how are judges appointed? Well, Article 2, Section 2, Clause 2 of the Supreme Court appointment process says that the president shall nominate and with the advice, consent, and consent of the Senate shall appoint judges for the Supreme Court. So usually appointing judges includes party affiliation. A president may favor judges who belong to their political party. Judicial philosophy. This helps the president to keep his ideology long after after the president has gone. The judge can continue to hear cases that follow along the same ideology as the president. Sometimes the president will ask a senator from the same party from the state of the needed judge to recommend some candidates, and usually the background of the candidate will have legal training and have served as a state court judge. So let's take a look at the Supreme Court, also known as SCOTUS. So the Supreme Court is the ultimate court of appeals in the United States. If the Supreme Court doesn't agree with you, then you have no more chances. They usually determine their decisions by the rule of law or process, not the merit of the case. They're really looking at law procedure and errors in the handling of the cases. They are the final authority in any case involving the Constitution and acts of Congress and treaties with other nations. So their power, the Supreme Court, to hear a case is discretionary or not required to hear any cases at all. If the Supreme Court chooses not to hear a case, the lower court ruling stands. So the Supreme Court chooses which case they decide to hear. If they choose not to hear a case, they don't have to give a reason why or a rationale why they have chosen not to hear it. Until 1891, justices spent a lot of their time riding the circuit, traveling to hold court in their assigned regions of the country. Each Supreme Court justice has an assigned region of the federal circuit. So the Supreme Court has both original and appellate jurisdiction. Article 3, Section 2 sets the court's original and jurisdiction and covers two types of cases. Supreme Courts will hear representations of foreign governments. Okay, if a foreign government wants or a foreign country wants to sue the United States, then the Supreme Court's going to handle that. Or if a state wants to sue the United States, or a state wants to sue another state, then the Supreme Court is going to handle that as well. So the Supreme Court is in session on the first Monday of October each year and usually continues in session through June. They hear usually between 500 and 500 and I think I've got a wrong number there. Usually the Supreme Court only hears about 150 cases a year. I think I got some messed up numbers there. The cases are heard with all the justices sitting together in open court. Each year, the Supreme Court hears about 150 cases of national importance, and 3/4 of the decisions are announced in full, published opinions. For the constitutional courts, their term is life. In other words, they keep their job until they resign, retire, or die. They can be removed through impeachment. 13 have been impeached, 7 of them have been removed. The salary is set by Congress, can't be decreased during their term. Their salaries are usually in line with that of senators, representatives, and the vice president. The justices and their main duties are to hear and rule on cases. They should decide which case to hear. And give an explanation of their opinion of the case. This is the U.S. Supreme Court. It's located in the back of the U.S. Capitol building. These are our 9 Supreme Court justices. There are 8 associate justices led by a Chief Justice of the Supreme Court. And there they are. That's our current Supreme Court. John G. Roberts is the Chief Justice of the Supreme Court. He was appointed by George W. Bush in 2005. Neil M. Gorse is an Associate Justice. He's the newest Associate Justice. He was appointed by President Donald Trump in 2017. Anthony Kennedy is an Associate Justice. He was nominated by Ronald Reagan in 1988. Clarence Thomas is an Associate Justice. He was nominated by George H.W. Bush, that's W's father, in 1991. Ruth Bader Ginsburg is an Associate Justice. She was nominated by Bill Clinton in 1993. Stephen G. Breyer is an Associate Justice. He was nominated by Bill Clinton in 1994. Samuel Alito, nominated by George W. Bush, that's the son, in 2006. Sonia Sotomayor is Associate Justice. She was nominated by Barack Obama in 2009. And Elena Kagan. She was an Associate Justice, nominated by President Obama in 2010. So how are the Supreme Court justices selected? Usually their appointments are influenced by their political ideology, their partisanship. Like I said, you noticed these presidents nominate these justices, and they do so thinking that these justices will continue to roll in favor of their party, the different ways their party thinks. But they can also be influenced by interest groups or other justices, senators. The American Bar Association has a very important influence. It's been consulted by every president concerning federal nominations. Usually the committee rates a nominee as either well qualified, qualified, or not qualified. And so that concludes my PowerPoint and gives you kind of an idea about the American judicial system. So that's what we're going to be looking at in the coming days. And so I appreciate you listening to this PowerPoint lecture, and hope that if you have questions about the judicial system, you will reach out to your instructor. Thank you for listening.